So hello everyone, and welcome to this session that is being recorded on UN peace forces. The last time we saw each other, we had already some discussion on the news bite regarding UN peace forces. And as promised, I'm going to summarize the discussion and to add also some substance, since we didn't have a lot of time on this news bite. So the main discussion in relation to UN peace forces relates to the accountability of the UN for violations being committed by peacekeepers and also broader other failures of UN peace forces. So we had several news bites that related to situations of rape, sexual violence and abuses that were committed by peacekeepers, for instance, in the Central African Republic, and also other news bites that were related to the fact that in some cases, UN peacekeepers were unable to provide effective protection to the civilian population. So these are really the two main areas that we would want to cover. So this issue in relation to crimes committed by peacekeepers, in particular sexual abuses, was put forth very much in relation to the situation in Central African Republic, but unfortunately, it's an issue that has not been limited to that context. There were allegations, serious allegations that were recognized as being the reality of in Haiti, in South Sudan, and in the Democratic Republic of the Congo. So we know and we can say that in numerous peacekeeping operations there were instances of sexual violence and abuses by the blue helmets, by the peacekeepers. The UN reacted initially in a way that was clearly not satisfactory. There were allegations of some cover-up even being made by the UN, not wanting to recognize that those violations were happening. And in more recent years, I mean, there has been a lot that has been done by the UN to fight this situation, but there is still a lack of accountability for these violations committed by peacekeepers. The second set of issues, as I mentioned, is really the failure to protect the civilian population. You know that in numerous multi-dimensional peacekeeping operations, there is a mandate to protect the civilian population. It's called the POC mandate. It means that there is a clear duty and expectation from the peacekeepers that they protect the civilian population. So even if the peacekeeping forces are not committing themselves the violations, they cannot let insurgents, members of armed groups, for instance, commit serious violations, for instance, killing civilians or committing other crimes against civilians without intervening. So if they witness something like that happening, it's part of their mandate to respond by potentially even using force and deadly force as a last resort in order to impede these acts from happening. And unfortunately, it has been the case that in some peacekeeping operations, the peacekeepers were simply unable to do this, or they did not react as was expected from them. Now, as I mentioned, even if at the beginning the UN probably had an unsatisfactory reaction, they tried for many years now to do something about the sexual violence in particular that I mentioned earlier. So already at the time of Kofi Annan, there was a policy that was devised in 2003, which is the idea that there is a zero tolerance policy by the UN. So the UN really wanted to give a very strong signal to peacekeepers to say, well, this is not acceptable and we will not let this happen again, and we will take measures. So there is not only this policy, but a whole range of documents and strategies have been developed. So for instance, in 2005, there was a code of conduct that was prepared for the blue helmets. with 10 basic rules, which of course include also the prohibition of sexual violence. Not only that, they created a unit that would be able to address allegations of misconduct by peacekeepers. Then the General Assembly in 2007 developed a comprehensive strategy to provide appropriate support and assistance to victims of sexual violence. So to make sure that they would not only work on the behavior of the peacekeepers, but that they would also offer assistance to the victims. In 2013, there was a due diligence policy developed by the UN in order to be able to vet security forces for human rights abuses, so to make sure that peacekeepers that would be employed would not have a track record of having committed sexual abuses in the past. So it's really a verification about the security forces in particular. Then you remember that it was in 2015 that there was this huge scandal about the sexual abuses on a very important scale in Central African Republic, and this prompted further actions by the UN. So, for instance, under Secretary General Antonio Guterres, a number of reforms have been adopted since 2017. For instance, he created a position of a special coordinator tasked with improving the response to sexual exploitation and abuses. It was Christian Saunders who was in this position. Well, now I don't know exactly who that person will be, because you might have seen very recently that Christian Saunders is going to be replacing Lazzarini as the head of UNRWA. So he's doing an interim position for UNRWA. So probably they will have to hire someone else. Perhaps it's already done as a special coordinator. In any case, in 2017, a new strategy was developed to prevent and respond to sexual exploitation and abuses with a really victim-centered approach. So trying to provide sufficient and adequate support to the victims, also to make sure that they would be able to speak out, because that can be also very often an issue. We've seen that in the news bites, that sometimes the victims are afraid simply to tell about what happened to them, to approach the UN and to explain the misconduct of the peacekeepers. This is also understandable because, for the victims, they might not necessarily draw a strict line between the peacekeepers who conducted these acts and then the UN more broadly, because for them, the peacekeepers, they represent the UN. So the fact that the UN is at the same time offering the support sometimes can be misunderstood, or simply the victims might not know about it, or even if they know it, they don't trust the UN anymore because of the violations that were committed by the peacekeepers. So that can be still an issue, and that's why it's important for the UN to really focus on this support provided to victims. There has been also the creation of the victims' rights advocate, again, with this victim-centered approach. There is a misconduct tracking system to increase the transparency around the allegations of violations. So there is really a possibility for the UN to better track and monitor those allegations, because sometimes it allows also the UN to better identify the persons who are putting creating the problems. And lastly, for instance, in 2021, they strengthened the reporting mechanisms to make sure that the victims of sexual violence would be able also, thanks to the support provided by local NGOs and the civil society, they would be able to report about these sexual violences. So a lot has been done, but issues remain. The first main issue is, of course, that the fact that these situations of sexual violence and abuses, they continue. It continues to exist, and even we have more allegations Now we have to be careful about this data showing that there are even more allegations now than in the past, because on one hand, it can be also a sign that the victims are ready to speak up. The more you offer the possibility for victims to speak up, the more you will have allegations. So it does not necessarily mean that everything that has been put in place by the UN is not working. It simply means that the phenomenon and the issue remains, and that victims are probably now more comfortable, or there are more venues to talk about what happened to them. A second issue is that even though we have lots of policies and strategies that were devised by the UN, there is a lack of implementation. So I mentioned already the lack of reporting by the victims, because they might also fear reprisals. They might not know about the venues, the avenues to do that. They might consider that the UN is not independent. So we know that independence is very important, for instance, when you have investigations or when you provide support to victims. But at the same time, I don't think that it's a structural issue. I mean, you do have different units conducting those investigations. So I think we can trust the fact that they are independent. But even if that is the case, the perception of independence is also very important. And the fact that everything happens within this bubble of the UN might raise this issue of appearance of a UN that is not actually of investigations or reporting mechanisms that are not truly independent. There is the need also to have a real change of culture. So it's been great that the UN devised a zero tolerance policy, but that needs to, not stay in New York or in Geneva. It needs to go back to the field where things are happening. So the change of culture is underway, but probably it's not completely there yet. A third issue that we discussed very much together is the lack of justice. So we don't have really justice mechanisms to deal with these allegations. We know that the UN is conducting initial investigations, in particular to be able to determine whether the allegations of violations are credible. But then you need to have further investigations conducted, for instance, by the troop contributing countries. When it comes to military peacekeepers, it's for the troop contributing country to prosecute. But to do that, they need also to have their own investigations to gather the evidence, which might be sometimes difficult to do because the troop contributing countries do not have access to the territory. So this is why you need also to have the collaboration of the host state to be able to collect the evidence. So ideally, we would need to have a triangular relationship between the UN, the troop contributing countries, and the host state to be able to conduct appropriate investigations. Now, even if we have initial investigations by the UN, potentially further investigations by the TCCs as expected, there are actually, in practice, very rare prosecutions of peacekeepers who are accused of abuses. So generally, what happens is that they might be demoted, so they are sent back home. They might lose their job, basically, but it does not necessarily lead to criminal prosecutions. And when we are talking about violations of such a gravity, being demoted is not sufficient. There needs to be a response that is appropriate, and the appropriate response is a criminal prosecution. And unfortunately, this does not happen, or at least very rarely. So this is why you have several initiatives that have been developed. For instance, the civil society and a number of NGOs have coalesced in order to launch a campaign which is called the Code Blue campaign, and which advocates for an independent special court mechanism within the UN, which would be able to deal with sexual violence by UN peacekeepers. So as we discussed during the discussion of the news bites, this is something that is totally feasible. As you know, the Security Council has been able to to create the ICTY, the ICTR. So it's not impossible for the UN to create courts And therefore, if there would be a political will, there would be a way to have an internal system of prosecution within the United Nations. But for the time being, it has not led to any initiative within the UN to have such a court. So the UN mindset is that this is an obligation for the troop contributing countries, and it's not necessarily for the UN to replace the troop contributing countries in this endeavor. The last big issue is the lack of assistance to victims. If you look at the portion of budget that is allocated to provide reparation to victims compared to everything else that is being done by the UN, you see that the portion of the budget is very, very tiny, very small. So there is clearly an insufficient funding for victim assistance. And unfortunately, the assistance of victims of sexual violence can be very expensive, because we are talking not only about medical assistance, but also you need to solve legal issues. For instance, sometimes the victims become pregnant because they have been impregnated by rape. And so what are these women going to do with these children who are not being recognized by the fathers? So that's also a great issue that the UN needs to deal with. It's really this issue of children that have been born out of rape by peacekeepers. So that's also a very important question of how to address these paternity claims. So now, first legal question: are UN peace forces bound by the prohibition of rape and other forms of sexual violence? Well, first, we have to recall that sexual violence is prohibited by two broad international legal frameworks. First, international humanitarian law that applies in armed conflict situations, and second, international human rights law that applies at all times. For international humanitarian law, to be able to say that a rape amounts to a serious violation of IHL, you need to show that there is a armed conflict that is underway, and also that this rape was conducted in connection with an armed conflict situation. So that's the famous nexus that needs to be proven. This nexus is usually considered as a given when the rape and sexual violence was done by peacekeepers, because the mere presence of the peacekeepers in the field is related to the fact that there was an armed conflict situation. Then in IHL treaties, you have several ways of prohibiting sexual violence. So, for instance, you have firstly the explicit prohibition of rape, enforced prostitution, any form of indecent assault, but also indirectly the prohibition of torture, cruel, inhuman, and degrading treatments would also prohibit sexual violence. You have also other terms that are being used in the Geneva Conventions, such as attacks on honor. And this was a way to say 1949. These are all treaties, so that's why the vocabulary is now a little bit odd. But these attacks on honor were basically referring to situations of sexual violence. For non-international armed conflicts, you have the prohibition of torture, CIDT in Common Article 3, and in Article 4, Additional Protocol 2, you have the explicit prohibition of rape, not only against women, but also against men. So that's also something to mention, that from an IHL perspective, especially in the additional protocols, that there was already this recognition that rape is not only an issue for women, but also for men. This has also been vastly recognized by the ICTY and ICTR jurisprudence. In addition to treaty law, you have customary law, and if you look at the customary IHL study that was developed by the ICSC, there is a specific rule that deals with the prohibition of rape and other forms of sexual violence. Last but not least, rape amounts to a war crime, so a serious violation of IHL. You can check the ICC statute, which criminalizes rape, sexual slavery, and forced prostitution forced pregnancy, and enforced sterilization. And this is for international and non-international armed conflicts. Then the key question in relation to all of this is, are UN peace forces bound by these IHL rules? Because basically the UN cannot ratify the Geneva Conventions and the additional protocols. And as we shall see in the next slide, even if the UN has not ratified those treaties through customary law and other also documents such as the Secretary General Bulletin on International Humanitarian Law, it is now considered as admitted that the UN is bound by those prohibitions. Then under international human rights law, there is the prohibition of sexual violence under many different forms. First and foremost, under the form of the prohibition of torture and CIDT. Because actually in many human rights treaties, you don't find explicitly the prohibition of rape. So you see there that IHL in some cases was more developed than human rights law, because for instance, in the ICCPR, you don't find that. In the UN CAT, there is no specific reference to rape or sexual violence, and not even in CEDAW. There is, of course, some jurisprudence of the CEDAW committee recognizing that gender-based violence is a form of discrimination that is prohibited by the CEDAW treaty. But you don't have an explicit prohibition. It doesn't mean that it's not prohibited, it's just mean that you need to go through other provisions to get there. In Africa, in the African system, there is this very important Maputo Protocol on the protection of women, which provides for explicit prohibitions of violence, sexual violence against women, including, sexual violence against women and violence more broadly. So here, again, the key issue is whether the UN peace forces would be bound by human rights law. You know that human rights law in general is considered as binding upon states, and you know also that the UN has not ratified those human rights treaties. But still, these obligations and prohibitions, they belong to customary law. And in addition to this, the UN has been really at the basis of the development of human rights law. So how could the UN, which promoted human rights, which made human rights emerge as an international legal framework, not be bound itself by human rights law? So this is, for these reasons, we can nowadays consider that the UN peace forces are indeed bound by this prohibition of rape and other forms of sexual violence, even if they did not ratify the relevant treaties. So you can provide different arguments. First, the promotion of human rights law is already embedded in the UN Charter. So if the UN needs to promote human rights law, then it also needs to respect it. Then you can also look at the mandates provided by the Security Council very often. These mandates might include also an explicit reference to IHL and human rights law. Especially since the 2000s, many of these resolutions of the Security Council that create UN peace forces, they do integrate a provision that relates to the respect for IHL and human rights law. Then there is the customary law argument that I mentioned several times. We can also mention the criminalized IHL rules. So you know that war crimes might be committed not only by belligerent parties, but also individual civilians. So it doesn't matter whether the UN was a belligerent party. What matters is simply that if a rape has been conducted by a peacekeeper, this will give rise to the individual criminal responsibility of this individual. So this is clear that criminalized IHL rules apply to every individual, whether he or she represents the state or not. The last point here is the Secretary General Bulletin of 1999, where for the first time the UN records some fundamental rules and principles of IHL that would be binding and applicable to UN peace forces. Today, it seems all of this seems obvious, right? That the UN is bound by IHL. But you have to realize that a lot of negotiation was ongoing. A lot of pressure was put by the ICRC and other actors on the UN to be able to, for them to recognize that they were bound by IHL. Because the initial reactions of the UN was to say, well, we are the UN, we are not a belligerent party, we are going to go in this context in order to maintain peace. So we cannot say that IHL applies to us because we are not a belligerent party. So it was very important to have, a lot of pressure by the civil society to say, no, it's not enough to say that you're not a belligerent party. And by the way, in certain cases, the UN might become a belligerent party, even if they don't want it. So if you have UN peacekeepers being deployed in a situation where the peace is very volatile, and then you have armed groups starting to attack the UN peacekeepers, the UN peacekeepers might have to react by using force, and you might have armed clashes actually between the UN and between these insurgents or these non-state actors. So if you then have armed clashes of a sufficiently high intensity, you have an armed conflict, right? So it's not the UN who would decide whether they are a party to a conflict or not. It's simply the facts on the ground. And because IHL is a very objective legal framework, it looks at what's happening on the ground rather than on the intention of the different stakeholders. So that was a very important recognition in 1999 only that IHL was applicable to UN peace forces. Now, may the UN and states criminally prosecute peacekeepers who have perpetrated crimes? So that's a quite crucial slide here, because this is really related to this famous accountability gap of UN peacekeepers. So first, let's look at what the UN can do. Well, at the level of the UN, for the time being, we have no court to prosecute peacekeepers, as I said. And therefore, the only thing that the UN can do is to initiate investigations, internal investigations, in order to be able to determine whether there is a credible allegation of rape and sexual violence. And then they pass the ball to the troop contributing countries, which have to continue the investigations and to potentially prosecute if there is enough evidence to do so. So these investigations are technically, can be said technically as being independent because they are different from the chain of command of the peacekeepers. So it's a different part of the UN conducting those investigations. But as I said before, it's a question then of the appearance of independence. But technically, yes, they are independent investigations. Now, we see that it's not the UN which could prosecute. So we go to the states. And for the states, we have to distinguish different states. First, you have the troop contributing countries, so the famous TCCs. The troop contributing countries are these countries which are lending peacekeepers, so members of their armed forces, to the UN to become peacekeepers. So it's the troop contributing countries which have the obligation to prosecute members of their troops who committed crimes under international or domestic law. This is being recognized in the Memorandum of Understanding, so the MOU that is signed between the troop contributing countries and the UN, that it is really the exclusive competence of the TCC to prosecute the military forces when they commit crimes. For civilian staff, it's a little bit more complicated because it depends on the civilian staff. We are talking about some of them benefit from immunities, while others would not. And in their case, they would rather be prosecuted by the host state, so the territorial state. The problem with the troop contributing countries is that even if they are acting in good faith and even if they would want to conduct investigations, it might be difficult for them to gather evidence because they are not on the ground. And if they don't have the collaboration of the host state, it's a bit difficult to do so. That's one argument. At the same time, we have also to recognize that sometimes it's for other reasons, because they don't want to have this impact on their image of saying, well, we have members of our troops that are not actually trained adequately, that are not disciplined. And therefore, for some states, they simply don't want to invest the resources in order to prosecute these individuals, and they don't want to recognize that this is happening. Then for the host state, so the host state signs a SOFA agreement with the UN. It's called it's the UN Model Status of Force Agreement. And in the SOFA agreement, first they recognize that the troop contributing country has the exclusive jurisdiction for the prosecution of the troops. And second, for the civilian staff, there is the recognition of the functional immunities, these famous immunities for acts that are thus performed by the civilian peacekeepers in their official capacity. Now, these are not absolute immunities. And certainly the UN can waive these immunities in order to let the host state prosecute the peacekeepers and so the civilian members of the peacekeepers of the peacekeeping operation who committed those crimes. But in practice, the UN has interpreted quite broadly those immunities. We don't really know why. I think it's really problematic because there is, a double standard in a sense that they try to put in place a zero tolerance policy. They put in place all these mechanisms and strategies, but at the same time, they provided probably a too broad definition of these functional immunities, and they are very reluctant in waiving those immunities. Perhaps it's also because there is a kind of lack of trust in the host state. So there is a risk that the host state might use such allegations in order to say that the UN is not doing an adequate job, and to somehow question the legitimacy, the credibility, and the mission of the UN. So that's a possible reason why there is very rare waiving by the UN Secretary General. In addition to that, even without the waiving, the host state might consider also that the immunities would not apply, especially if the peacekeepers have conducted those crimes while they were not acting in their official capacity. We mentioned the case that they go in a bar in the evening, they are off duty, and in such a context they conduct these abuses. We cannot say that it was done in their official capacity. So it's even outside the scope of the immunities. But again, we are talking about host states which are confronted with an armed conflict, so they might not even have the time capacity to prosecute, and they have other priorities because they are faced with these hostilities. For other states might also have a basis of jurisdiction. Of course, not a territorial basis of jurisdiction, but based on the active or passive personality principle. So the active personality principle means that you look at the nationality of the person who is accused of a crime, and so that's the state of nationality. And the passive personality is based on the nationality of the victim, not the perpetrator. Lastly, as sexual crimes might amount to serious violations of IHL, and especially grave breaches in an international, if it's connected to an international armed conflict, you have the universal jurisdiction, meaning that all states normally should have a law which allows them to prosecute irrespective of the nationality of the perpetrator or the victim or the territorial link. In practice, unfortunately, even if there is such an obligation, very few states have implemented the obligatory universal jurisdiction. And last point on universal jurisdiction, even in relation to serious violations committed in a NIAC, states might provide for universal jurisdiction in their domestic system, It's not required by international law, but they can do that. Now, may UN troop contributing countries be held accountable for failures of UN peace forces? So here it's also the question of attribution. How are we going to attribute the violations committed by peacekeepers? And this is actually a quite contested legal issue, quite intricate legal issue. The starting point to answer this question is to look at the International Law Commission's draft articles on the responsibility of international organizations, which provide in Article 7 that you would want to see whether the acts were performed under the effective control of an organization to be able to attribute those acts to an international organization. So let us read this article. It says, the conduct of an organ of a state, so let's say the troops that are provided by a troop contributing country, or an organ of agent of an international organization, that is not relevant for us, that is placed at the disposal of another international organization, so placed at the disposal of the UN, shall be considered under international law an act of the latter organization if the organization exercises effective control over that conduct. So here, the crucial question is whether the UN is exercising effective control over peacekeepers when they commit those crimes. So it shows that the UN can be held responsible for violations committed by peacekeepers. Now, the tricky question, I think one of you asked this question when we had the class last time, is whether you can have a dual attribution, that the act of the peacekeeper would be attributed not only to the UN, but also to the troop contributing country. And indeed, if you look at some jurisprudence at the domestic level, for instance, in the Netherlands, dual attribution has been accepted. Even if you look at the ILC commentary to Article 7, there is an implicit recognition that you might have dual attribution. So the ILC is saying that this does not impede an attribution based on the articles on state responsibility. But in judicial practice, we don't have much case law where a court recognizes this dual attribution. So if you take, for instance, the Berami case in front of the European Court of Human Rights, it was rather the opposite. The court did not go for the dual attribution, and it considered that acts of UN peacekeepers were attributable to the UN, and therefore the court considered that the case was inadmissible. So you see that the judicial practice is not so much going in the direction of dual attribution. I mentioned here an article by Tristan Ferraro, where he considers that it's not really pragmatic to go for the dual attribution, that there would be a risk of dilution of responsibility. So he's of the view that we have to look at whether the UN has the operational control. And if that is the case, he would go for an attribution to the UN only, and not to he would not necessarily consider a dual attribution. Now, even if we accept this notion of operational control and effective control, which is the case, when you have peacekeepers, usually it's not the troop contributing countries having the control, but rather the UN, it remains unclear how we would have to interpret this effective control. So for instance, if you have UN peacekeepers conducting a military operation, and in that context committing sexual crimes and abuses, do we consider that the UN was having an effective control? Most probably they had an effective control over the operation, but did they have a control over the conduct? So you see here, it says effective control over that conduct. So that's where the issue lies. How should we interpret this? Should it be a narrow interpretation, a broad interpretation? So as you see, in terms of responsibility, you have a lot of question marks about this dual attribution and also the amount, or rather the level at which you would analyze this effective control. In any case, if we consider that, for instance, in the context of this operation, the UN was responsible and we don't look at effective control of the conductor, but more broadly at effective control of the operation, there is then an obligation of the UN to ensure the continued performance of the rules, to make sure that these violations are stopped, so that cessation and non-repetition and reparation. Reparation is the key aspect, as we see, and the UN has recognized this because they developed this trust fund, which is tiny, but still they recognize that they need to repair for these violations committed by peacekeepers. However, as we can see, there is a risk of having an accountability gap because of UN immunity. So even if we say the UN is responsible when peacekeepers commit, like in CAR, there are massive allegations and cases of sexual violence, the UN is responsible, but what do we do with that? We cannot bring the UN in front of a court. There isn't, and they cannot be brought in front of domestic courts because of the immunities that belong to the UN as such. So there is really this issue of an accountability gap, not only in relation to the peacekeepers, that is what we discussed already, but also in relation to the UN as being responsible for what's happening. I'm moving on to the question of the protection of civilians. As I mentioned, in many Security Council mandates, there is an obligation to use all necessary means to protect the civilians under threat of physical violence. Meaning, if members of non-state actors or soldiers, for that matter, commit violations against the civilian population, then the UN peacekeepers must intervene to make to halt those violations. So usually, when there is a POC mandate, the resolution is adopted under Chapter 7. It's not a peace enforcement operation. It's not an Article 42 military operation. It remains a peacekeeping operation, but a robust peacekeeping operation where the peacekeepers can use deadly force to protect the civilian population. So that's the basis of this legal obligation, the Security Council resolution. But we can say also that the duty to protect is broader. It flows from human rights law, from the right to life, where you have a positive duty to protect life. It can also be derived from international humanitarian law, notably the obligation to respect and ensure respect for IHL that you find in Common Article 1 to the Geneva Conventions. It can also be derived from the obligation to take precautionary measures against the effects of attacks. So that's the passive precautions, so meaning that the UN might have to take passive precautions to protect the civilians from the attacks performed by others. It's a little bit trickier if the UN is not a belligerent party, but still it's a relevant legal obligation. So this duty to protect the civilians flows from the mandate, but also from general international legal frameworks such as IHL and human rights law. So why? Because the legal basis is there, but in practice, we see that in some cases, UN peace forces were unable to effectively protect civilians. Why? Well, here we cannot have a single answer. It depends on the context, and often it's multifaceted. It can be because the mandate is not clear enough. So, for instance, if there is some gray area about what is expected from the forces, that might be an issue. It might be an issue of the forces being insufficiently staffed, or not having the appropriate resources, not the appropriate defensive equipment, not the appropriate weapons. So these might be reasons why concretely the peacekeepers might not want to intervene. They might not be appropriately trained to know how to intervene. So that can be a problem of training of the forces. There might be also a lack of incentives for taking on more risks. This is very human. You know, the peacekeepers are being deployed, but it's not that they fight for their state. You know, it's different. In a peacekeeping operation, it's understandable that single peacekeepers might be less incentivized to act in order to protect the population in a conflict that is very far from their own preoccupations, if you see what I mean. They might have also the fear of consequences or risk that there might be a spillover in the violence. So the risk that the UN might then be directly attacked. So that might also explain this cautious approach, especially if the violations are committed by the governmental forces. Because if that is the case and the UN reacts, the risk is what? That the host state is going to withdraw the consent. You see? So it depends also on who is projecting this violence. Is it the state forces or is it non-state actors? Because for the state forces, the UN depends on the host state to be present on the ground. It can be also a question of lack of impartiality, that somehow the forces might react when certain individuals might be the victims, but not others. It could be a lack of trust also among the population, which explains why those attacks might happen. And the complexity of the mission and of the local situation, political situation. So, I mean, it is multifaceted, and certainly the UN has to act on several fronts to be able to make sure that their forces are going to be effective on the ground and that they are really going to implement the POC mandate. All right, so this is all for the news bite. I'm going to take a little break and then I'm going to present the basic principles. Thank you for your attention and I'll be back in a few minutes. So I'll be back, Natasha. See you.
Okay, that's great.
Okay, let's have a look now at the law and practice of the UN in relation to UN peace forces. So the first thing to recall is that peacekeeping was not foreseen by the UN Charter. So you can read the UN Charter from the first page until the last one, and you are not going to find any reference to UN peacekeeping. So that was really a creation based on practice. And so the first time UN peace forces were deployed was in the context of the Suez crisis. So you might recall from your courses in history that it happened in 1956 when Egypt, which was governed by Nasser, decided to nationalize the Suez Canal Company. And the UK and France had, of course, economical interests that were intrinsically linked to the Suez Canal Company. The Suez Canal is also a very strategic canal. It's also a way to get access to the Middle East. It's where the trade of oil is going. So you see, Hormuz is nothing new. I mean, if you see the situation that was there in Suez, you can see also links between the two. So basically, after Egypt decided to nationalize this Suez Canal, the UK, France, and Israel decided to intervene militarily, and they started occupying the Sinai Peninsula, Gaza also. At the time it was, so Israel occupying those parts. And as you can see, the Suez Canal was occupied by the UK and France. But there was no support for this from the US and the USSR, and therefore, despite the fact that the Security Council was blocked because of the vetoes by France and the UK, the question was passed to the UN General Assembly through the Uniting for Peace resolution. You know, this famous resolution we discussed, the Akasan resolution. And therefore, then the General Assembly called for a ceasefire and asked the troops to retreat. And they created the first UN peace forces with blue helmets that were sent in order to monitor the withdrawal of these forces of occupation. So basically, even if there was the UK, France, and Israel were capable militarily to conduct this operation, politically, they did not have the support of the international community, and they had to withdraw, which was a very important backlash, both for France and the UK. It showed that they were not, these imperial powers of the past. They were really in a situation where they could not stay. So basically, it was an invention by the Secretary General at the time, Dag Hammarskjöld, who said, well, let's create then UN peace forces, and then let's send these blue helmets to make sure that the situation goes back on track. So it was a creation by the General Assembly through the Uniting for Peace resolution. As you remember, the UN General Assembly cannot have a power of decision. It cannot have a coercive intervention like a peace enforcement intervention, but they could recommend the creation of this peacekeeping operation and actually send this peacekeeping operation. So that was the very beginning of a very long story of UN peace forces. Now, based on this practice, we might ask ourselves, what is the legal basis of UN peace forces since they were not anticipated by the UN Charter? And that is not entirely clear what the legal basis here is. Generally, we tend to locate peace forces in Chapter 6 because you know that Chapter 6 is about the peaceful settlement of disputes. So it's a way to settle a dispute peacefully. It's not coercive. That's why usually we tend to think about Chapter 6. But actually, and many recent peacekeeping operations are created on the basis of Chapter 7 when the Security Council wants to give a robust mandate to the peacekeepers. So it can be a Chapter 7. In Chapter 7, we could locate it in Article 40, so on the provisional measures, because it's not an enforcement operation 42, but rather a provisional measure that is adopted under Chapter 7. Some say in scholarly writings that there is a kind of Chapter 6.5 between Chapter 6 and Chapter 7 that would be about peacekeeping. So showing that it's not really a Chapter 6, not really a Chapter 7. So that would be a secret chapter that we cannot read that would provide the legal basis. Still, other lawyers considered that actually it's the theory of implied powers that is the best suited to explain the legal basis. So here you have a quotation by Jiménez de Arriaga saying, peacekeeping operations, a term not used in the Charter, constitutes a development of the Charter which has no basis in Chapter 6 or Chapter 7 either. but results from the implied powers of the United Nations for the realization of its basic purpose, the maintenance of peace and security, and the taking of effective collective measures to that end. So you remember that the ICJ in the reparations advisory opinion explains that the United Nations and international organizations do not only have explicit powers based on their constitutive treaty, let's say here the UN Charter, but that they have also implied powers that can be derived from their functions, from their mission. So since the mission of the UN is to maintain peace and security, it can decide to create something like the peacekeeping operations, which enables the UN to fulfill its mandate, its function. In any case, you always have to check the resolution that creates the peacekeeping operation, because if you have an explicit reference to a certain chapter, then there is even no doubt about this. So if the Security Council is, for instance, providing a POC mandate under Chapter 7, then you know that it's based on Chapter 7 and therefore Article 40. So probably, in my view, the most convincing answer is it depends on the peacekeeping operation, and if you have a legal basis that is already clearly provided in the mandate, there is not much controversy. It's more complex when you don't have such an explicit mandate or such an explicit reference to the legal basis. What types of activities are performed by UN peace forces? On this, there has been a clear evolution. Some people talk about different generations of UN peacekeeping operations. When the peacekeeping operations were created, the idea was to have, a peacekeeping force that was made mainly of soldiers, so it was very military, and the typical function was to maintain a ceasefire. So it was basically interposition between the belligerent parties, very reduced, very military, so confined, if you want. But if you look at the peacekeeping operations today, they are very different from those like for Suez or Cyprus when they were created. The peacekeeping operations of today are generally called multidimensional peacekeeping, because it's not only about the military, you have also the civilian component that is very important. So basically, the UN is going to provide services not only to maintain a buffer zone, but also to help the political process, to make sure that the members of the armed forces and armed groups are being demobilized. So you have political tasks, you have peace building tasks. It's really very multifaceted. So it's a mix of military, police, also to maintain law and order, civilian capabilities to implement also a comprehensive peace agreement, if there is one that is clearly there, or they can also help in the development of such a peace agreement. So the main objective is to create a safe environment and to also, in some cases, to protect civilians from imminent threat of physical violence. That's the famous POC mandate we were talking about. But as I said, you can have also peace-building activities, so disarmament, demobilization, and reintegration of ex-combatants. We call that the DDR activities. You can have mine action, so removing landmines to protect the population, reforming the security sector, so training the police in law enforcement techniques, protecting and promoting human rights, building commissions for the respect of human rights, providing assistance in elections, in the processes leading to elections, supporting the state in the restoration of its authority, or even social and economic recovery. And in certain extreme cases, the UN has been almost replacing the state. When there was, for instance, a transition, let's take the typical cases at Kosovo and East Timor, with Kosovo, you remember that Kosovo wanted to become an independent state, but of course there was no government to be able to do this. So you are in a phase of transition, and the UN is somehow, replacing all the functions of a state for a transitional period. So it can go very, very far, basically. At the UN, you have several concepts that are turning around this notion of peace. And so I just wanted to show you here a graph that was devised by the UN in the Capstone Doctrine, which is a reference document to know more about UN peace forces. So if you are interested, in UN peace forces, that's a very good document to read. And as you can see here, you have different bubbles related to the political process and different phases. When you have a situation of tension, but you're not yet reaching the stage of a conflict, the UN is involved in conflict prevention. So you have early warning processes to make sure that the situation would not give rise to proper armed conflicts. You have good offices that can be provided by the Secretary General. Sometimes you have even a preventive deployment of confidence building measures. Then if the conflict arrives, the UN is going to provide support for peacemaking. So there basically it's to provide support for diplomatic action, to have the negotiation of a peace agreement. In other cases, the UN might have to intervene by peace enforcement, meaning that the Security Council would adopt a resolution based on Article 42 and allow states to take all necessary measures. So that's the coercive aspect. And normally peacekeeping operations, properly saying, are being deployed when you have already a ceasefire. So it comes after the ceasefire. So you send UN troops to maintain the ceasefire. But sometimes you have gray areas where, peacekeeping becomes very close to peace enforcement and peacemaking. So for instance, as I said, the peacekeepers can use deadly force if they have typically, in the context of a POC mandate, it's even proactive force that can be deployed. And so sometimes it might look like a peace enforcement operation, but it isn't a peace enforcement operation. So you see the gray area between peace enforcement and peacekeeping. That's the kind of overlap, because in both cases, you have a deployment of force. The big difference is that for peace enforcement, it's a strategic use of force. So the UN decides to launch a peace enforcement operation, and so it comes really from the strategic level. For peacekeepers, it's not like this. It's more at the tactical level, when the peacekeepers have to defend themselves, defend their unit, their mission, protect the civilian population. So it's very tactical. It's not the objective, if you want. The objective is to maintain the peace, and they might have to use force at the tactical level in order to prevent the situation from escalating and from getting back to a situation of an armed conflict. So just to show you that these are different concepts, but that there are sometimes overlaps, and that the use of force is part of peacekeeping and peace enforcement operations, but at different levels. It's very important to recall that UN peace forces are based on three main principles. So it was implicit in the entire discussion that we had last time, but let's recall that first, peacekeepers can be deployed only if you have the consent of the relevant parties, so the belligerent parties. And if it's in the context of a non-international armed conflict, this might also involve the consent of armed groups, for instance, de facto authorities controlling territories. and of course the host state. So the consent of the parties is required, while for peace enforcement it's not the case. It's when the Security Council says there is a threat to the peace, a breach of the peace, or an act of aggression, and it's a coercive action. Instead, for peacekeeping, consent is required. Second is that the UN is positioning itself as an impartial actor. It's not taking sides, as in coercive action, as in peace enforcement. Here, for peacekeeping, the UN is not saying you are the aggressor and you are the aggressed. It's not the mindset. The mindset is that we are coming to maintain the peace, to help you in the peace process, and we are an impartial actor. So it's a very different positioning when you compare peace enforcement and peacekeeping. Third point is that in principle, the peacekeepers are not supposed to use force except in self-defense, meaning for defending themselves, defending members of their units, and also defending the mandate. And as I said, in some cases, they have an explicit POC mandate, which would lead to the potential use of force when required. So this is a quotation from the Capstone Doctrine to really draw the line between robust peacekeeping and peace enforcement. It says, although on the ground they may sometimes appear similar, robust peacekeeping should not be confused with peace enforcement as envisaged under Chapter 7 of the Charter. Robust peacekeeping involves the use of force at the tactical level with the authorization of the Security Council and consent of the host nation and all the main parties to the conflict. By contrast, peace enforcement does not require the consent of the main parties and may involve the use of military force at the strategic or international level, which is normally prohibited for member states under Article 2.4 of the UN Charter, unless authorized by the Security Council. So it's summarizing very well what I tried to say before. What does protection of civilians mean in the context of UN peace operations? First, this POC mandate, the famous POC mandate, is rather recent. In the initial peacekeeping operations, there was no POC mandate. The idea of having such type of mandates came from the failures of the UN in contexts like Rwanda, Somalia, former Yugoslavia, with the Srebrenica massacre. So these crises in which the UN deployed peacekeepers, but they were unable to prevent massive crimes, international crimes from happening. So the idea was that it was not sufficient to simply send forces without making sure that they would have the means to protect effectively the population. Because even if you have a ceasefire, it does not impede that a situation might become extremely violent. And therefore, you have to be able, as the UN, to prevent such international crimes from happening. So today, the majority of UN peacekeeping missions have a POC mandate, but it was only in 1999 that the first POC mandate was created. I already mentioned the legal basis before, so I'm not going to repeat that. In terms of activities, of course, it involves the use of deadly force as a last resort, but it's not only that POC, it's also ensuring respect for IHL and human rights law more broadly, which might include advocacy activities, monitoring of human rights law compliance, strengthening the rule of law in the state. So it's a pretty broad concept, even if often we just think about the use of force, but it's not only that. Whose responsibility to make sure that civilians are not killed, not victims of international crimes? Well, the primary responsibility lies with the host state. So it's not that the UN is going to replace the host state or take on all the responsibility. But the idea is that in some cases, the host state might be unable simply to provide an effective protection to civilians, and the UN, through the peace operation, is going to support the state in this endeavor. So there are some linkages with the responsibility to protect, the concept of responsibility to protect, However, it's not the same. The responsibility to protect, for instance, is not only connected to armed conflict situations, while POC mandates are connected to armed conflict situations. And POC is not only to prevent certain international crimes, but more broadly to ensure the respect for IHL and human rights law. So there is some overlap, but these are two different concepts. Are UN peace forces bound by IHL? I think that we covered that already. Here, what is new in this slide is the fourth bullet point about the status of peacekeepers. So peacekeepers are generally considered as civilians in the context of an armed conflict. So the belligerent parties cannot attack peacekeepers. They are protected civilians unless they directly participate in hostilities. So if they directly participate in hostilities, then they become targetable like any other civilian in an armed conflict. In the ICC statute, you have several provisions that mention that it is a war crime to attack, for instance, peacekeepers who are not directly participating in hostilities. So there is a protection of peacekeepers. Again, they are not supposed to be a belligerent parties, and so the presumption is that peacekeepers are civilians and that they do not take part in hostilities. Now, in certain cases, as I mentioned briefly at the beginning of this recording, in some cases, the UN might become a belligerent party even if they don't want to do so. And in such a context, then the situation would be different. Are UN peace forces bound by human rights law? We discussed this in relation to the news bite, so I'm not repeating what I said before. Just flagging one aspect here. Again, the fourth bullet point. It's about the extraterritorial application of human rights law. Just remember that the UN does not have a territory. And therefore, there is this question of whether human rights law would be applicable to the UN, because human rights law was really devised for states having a territory, etc. However, this notion of jurisdiction is not necessarily part of customary law. This is found in treaty law, in human rights treaties, but it's not necessarily part of customary law. So it's even a question whether it's a relevant concept in customary law. In any case, if, for instance, the UN would be detaining individuals, then jurisdiction would be given. Even if you don't have a territory, people might come under your jurisdiction. For the accountability, the discussion was already very intense on the news bite, so I refer to the above slides. And to end this recording, I would like to highlight that the UN had a wonderful idea to have these UN peace forces. So even if we discussed in the news bites these awful violations that have been committed by some peacekeepers, I think we should not disclaim completely the importance of UN peace forces. Of course not. I mean, it has been a huge progress that the UN has been able to support peace processes in numerous contexts thanks to peacekeeping operations. So it has had huge successes, and now it's considered as a key tool to maintain peace and security. The UN has invested great efforts in the professionalization of UN peacekeeping, and they really tried hard to have improvements. But of course, it's always important to remind about to record the challenges. I mean, it's not enough to have a wonderful tool. We have to make sure that there is still accountability for violations committed by UN peace forces, and on that there is still work to be done. I think we have seen that very, very clearly in our discussion. Beyond the accountability, there is always a need for the UN to be able to provide appropriate mandates funding weapons and training to UN peace forces. For sure, this was one of the reasons why we had these very important failures in former Yugoslavia, Rwanda, Somalia. It was in relation to these inappropriate mandates, inappropriate equipment of the forces, and staffing of the force. So it's really essential for the UN that when they decide to deploy UN peace forces, to make sure that they give them the tools to fulfill their mandates, and the mandates need to be very, very clear as possible. There is always an issue also of blurring of the lines between military operations and humanitarian development activities. What is particular in these multi-dimensional operations is precisely the fact that at the same time you have civilian component, trying to promote human rights law, but you have military forces being there and being able to use, sometimes even proactively force to ensure the fulfillment of their mandate. So there might be a blurring between these different activities, which might lead to problems in terms of perceptions, especially by the civilian population. So there is really a need to provide a better understanding of the functioning of these UN peace forces, and to make sure that the population knows who are the relevant actors and what they are doing there, to ensure that there is a trust that is being built. And ensuring accountability would increase that trust, and of course would increase the credibility and the legitimacy in UN peacekeeping operations. So this is all for today. I thank you very much for your attention, and also for your flexibility because of the changes that we had to make regarding the last session. So I wish you a very happy Easter, a nice break, and enjoy. Et joyeux 1er avril. Bye.